Sure. Yeah. No, I'm happy to go next. Thanks, Sarah. And yeah, thank you so much to Just Peace Advocates and everyone who organized tonight's panel. And it's great to be here with Sara and Yavar and Shane. And thanks so much, Yavar, for that great kind of setting of the scene and the explanation of the case of Irfan. It's definitely a case that, as you explained and as we've seen, has had, repercussions over the years since that case happened. Um, one thing just off the bat that I'll mention before getting into the specifics of the terrorist entities list is that in the last, I believe, 2 years, the government actually modified the laws around charities so that now, as soon as a charity is placed on the terrorist entities list, they're deemed to no longer have charitable status. So now they've just rendered it automatic. There's no need to go through a process. It's not that a charity can defend their status, but as soon as they're placed on the list, they're deemed no longer to be a charity, which means that they would first have to get themselves off the list in order to regain their charitable status. And of course, the justification for this is that, well, how could a charity be a terrorist entity? As soon as they're a terrorist entity, they must no longer be a charity. So I think that gives a good idea and a good segue into the actual concerns that the organization I work for and that I personally have around the terrorist entities list and why we want to join today's panel. So I work with the International Civil Liberties Monitoring Group. We're a coalition of 44 Canadian civil society organizations across the country, and we've been around since 2002. And we were actually founded explicitly in the wake of the adoption of Canada's first Anti-Terrorism Act in December 2001, after the attacks of 9/11, in recognition that there was this market increase and intense problem of these new laws being rushed in without study, and that were clearly going to have significant consequences on civil liberties in Canada and internationally, and that it also coincided with increases in surveillance, increases in cracking down at the border and border restrictions, increases in racism and xenophobia and Islamophobia, and that there need to be a collective response. And so since 2002, the coalition has been working to advocate against the impact of anti-terrorism laws and measures on civil liberties and human rights in Canada and Canada's role internationally, both directly and also this idea that Canada somehow is a good player on the international stage, is a good example to follow. And so we hear, talking with our international colleagues, that other countries look to Canada and say, well, if they have a terrorist entities list that operates in this way, that gives justification for our own use of these kinds of administrative measures. So one of the concerns that we've had since the beginning is that terrorism has been used to establish a set of laws that that essentially create exceptions to what's understood to be due process in the courts, what's considered to be protections around civil liberties, by creating this new category, as Sara, you mentioned, of terrorism charges, where terrorism is vague and is undefined. There's no consensus, and so it can be used in arbitrary and discriminatory ways. And one of those laws since the beginning has been the creation of the terrorist entities list regime. And so we have as a coalition have opposed it since the beginning. Have called and continue to call for it to be revoked for a few reasons. And we issued a statement after the listing of Samidoun explicitly going into some of that. And essentially that, as we've seen over the past 20 years, that's an arbitrary and political tool that undermines freedom of association, freedom of expression, and due process in the courts. And moreover, its effectiveness as a national security tool hasn't actually been demonstrated in a manner that justifies its use. There's never been an independent review of whether or not it's an effective tool, but we do know its impact, as Yavar laid out, on issues around charities, but also its impact on freedom of expression, freedom of association, and the chill that it creates. I was going to speak a little bit about how the list works. Others have touched on, but just to say that, again, it's a secret and discretionary process. And as Yavar was pointing out, that's a system where the government can consider any information, including untested evidence, untested intelligence. So the wording of the law is actually that they can accept anything, even if it wouldn't be admissible under normal criminal standards of evidence. And so, as Yavar mentioned, that's how secret intelligence from Israel or from other countries can be used in order to justify the minister's decisions. And then once it comes time to challenge the listing, it's nearly impossible because so much of the information is kept secret under security regulations. And I'll talk about that a little bit later because, in fact, in the government's rush to respond to foreign interference, there's actually been some changes to how the government handles these forms of secret. We don't like saying secret evidence, but secret information that they can use in these kinds of administrative proceedings. Um, so, sorry, I'm just catching up here. The other thing, and as Yaver pointed out, it also creates a situation where it's nearly impossible to mount a defense because it's impossible to raise funds in order to pay a lawyer. There's been some statements by the court that a pro bono lawyer would not necessarily be subject to criminal charges for supporting an illicit terrorist entity because it's not the intent of the law, but we would be, and I think anybody who would step up to represent a illicit entity would be concerned about what the repercussions could be and how that could be interpreted by, by future governments or by, depending on who's presiding in the court. And I think it's also